Kristen Mathews, and I'm a partner in MoFo's Privacy and Data Security Practice Group. And today, I'm going to talk about how the CCPA addresses service provider relationships. There's a myth out there that the CCPA requires that businesses amend all of their service provider agreements. Let me start by sharing with you where that myth came from. And this is important for you to evaluate the myth. So when you read the CCPA, you find that there are 3 different places within the law where there are criteria, or I'll call them ingredients, for what ought to be in a service provider agreement. One of them is the definition of service provider itself. That definition puts forth criteria for what should be in a service provider agreement. The other 2 places are other definitions within the CCPA. One is the definition of sale, and the other is the definition of third party. Both of those definitions contain exceptions from them for service providers. And that makes sense, right? Because when you share data with a service provider, you don't want that sharing to be considered a sale. And it shouldn't be, because that's not the typical nature of a service provider relationship. And as for the third party definition, it's natural that there would be a difference between a service provider and another kind of third party. But when you read all of these definitions together, you say to yourself, oh, I have to revise my service provider agreements to conform to all of these definitions. And by the way, the 3 of them are different. It's not like they're uniform. So you have to pull the ingredients from 3 different places, you think, and amend your service provider agreements to conform to all of them. So this is what you see in the press, and this is what we're calling a myth. Our clients didn't like this answer that they were seeing out there. So they challenged us, and we challenged ourselves to see if we could come up with a better answer. So we examined how each of these 3 definitions is used within the body of the law. And we found out that it might not be so bad not to meet these criteria. So let's take the most scary one first, which is the definition of sale. You definitely don't want your service provider relationships to be considered sales of data. Because if they are, it would mean you would have to give consumers the right to opt out of your transfer of their data to your service providers. That would prevent the job from getting done. And it clearly wasn't intended by the CCPA. So you definitely don't want your service provider relationships to be considered sales of data. But let's examine how we can get out of that. Well, first of all, I told you that there's a definition of sale and that there's an exception from the definition of sale. And it's difficult to fall into the exception, the service provider exception from the definition of sale. But maybe we don't need it. Look at the definition of sale before the exceptions. It doesn't really describe a service provider relationship in the first place. So maybe we could get out of the whole problem of sale without even using the service provider exception. Let's look at the other 2. The definition of service provider, which has criteria in it, and the definition of third party, which has an exception for service providers. In both cases, what would be the downside if you did not meet those criteria? Well, we thought about it. Turns out the downsides are not so bad. One of them is that you would have to make some additional disclosures in your privacy policy and in your disclosures upon consumer request. But those additional disclosures are not so bad. Boiled down, you would have to disclose the categories of third parties, non-service providers, with whom you share data, and the categories of data that you share with them. Not too difficult to do, and also sort of generic. The other downside is that you could lose a safe harbor that is available for sharing data with service providers. This is how the safe harbor goes. It basically says that when you share data with a service provider as defined, so we're worried about not achieving that. But if you did, when you share data with that service provider and the service provider fails to comply with the CCPA, you would not be responsible. And that sounds like a great thing, maybe worth achieving. However, first of all, even without that safe harbor, is there anything in the CCPA that would make us responsible for our service providers anyway? I don't really see anything. Second of all, the safe harbor only points to failures on the part of the service provider to comply with the CCPA. The CCPA doesn't really have much duties on service providers. The best example is probably their duty to assist with the deletion of data upon consumer request. And arguably, you're not responsible if they fail to do that anyway. So what we're doing for you here is we're trying to liberate you. We're freeing you up. Look at this service provider requirement a little bit more critically. Consider the pros and cons. Either you're going to be inventorying, reviewing, and revising hundreds of service provider agreements, or you're going to be suffering the downside of not doing so, which I've just described to you. Maybe prioritize which ones are worthwhile and which ones aren't. And let me give you some tips. What to prioritize? 2 things. 1, any service provider relationship where the service provider has the right to use personally identifiable information for their own purposes or for a third party's purposes. That's an agreement to review. And by the way, it might be very difficult for you in that situation to avoid the definition of sale anyway. The other type of relationship to prioritize, and this one we have a fix for, is a service provider relationship where the service provider has the right to use de-identified and/or aggregated personal information for its own purposes or for third-party purposes. If that's the case, there's a good fix for that. And let me tell you what it is. The CCPA has a definition of aggregated consumer data, and it also has a definition of de-identified data. If that service provider meets those definitions, the CCPA definitions, then their use of the de-identified or aggregated data for their own purposes won't be covered by the CCPA in the first place. So take a breather, think rationally and critically about what the CCPA really has to say about service provider agreements, put your service providers into buckets, and take a rational approach. I encourage you to take a look at the other videos in our series for more insights about the CCPA.